The court is in session in County Court of Law number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. We have our announcement docket, which was scheduled at 9 a.m. on today's date of January 21st of 2022. Our first case that we'll be calling is Alan Keith Eaglin.
Yes, sir.
Mr. Eaglin, is that your full name?
Yes, sir.
How you doing, Mr. Eaglin?
I'm doing okay. Yes, sir.
I'm doing fine. Thanks for asking. Mr. Eaglin, I see here that, okay, you was to hire an attorney, is that correct?
Yes, sir.
Have you hired your attorney?
No, sir. A week after you gave me that extension, I had got laid off. But fortunately, I started working again like 2 weeks ago. And I'm
Okay.
making a little over $21 an hour.
Okay,
And I have information from Mr. Cobb, and he, we talked this morning, and
okay,
he
so how
said
much
he'll
time,
represent me, so
so how much time do you need to hire your attorney?
another 60 days, is that okay?
Okay, we can reset it for 60. This is Alan Eaglin, bottom of page 1 on the announcement docket. Yes, now, Mr., did you provide proof to the court of your interlock?
No, sir, because I didn't, when I lost my job, I couldn't pay the stuff, but I'm getting on top of that. Back today when I leave.
Okay, you need to get your interlock.
Yes, sir. I understand.
Let's see, we're gonna give you until Monday to get it.
Okay, I get on top of it today.
Okay, you need to provide proof to the court. You could, you're gonna have to bring it to the court
Yes, sir.
or call our court. They can give you the fax number. We could be faxed.
Okay, and you said I got to do that by Monday, right?
Right.
Okay,
Okay, and you should not be driving any vehicle that does not have an interlock device installed.
yes, sir.
Any vehicle that you own or operate should not have an interlock, should have an interlock device on it. So you should not be driving an interlock, should be driving a vehicle without an interlock. If you are driving a vehicle without an interlock, that'll be a violation of your bond conditions and your
Okay.
warrant, and a warrant condition for your arrest, because your bond conditions will be revoked,
Okay,
okay?
I just have one question. When I had, on the other vehicle I had, before it got, broke down, I had to like make an appointment. It wasn't like available. Like, for instance, say I go there right now.
Okay, well, you just need to make that appointment and then let us know.
Let you know, okay.
Right,
Yes, sir.
all right. You stand on the X in front of our coordinator. Once you get your reset, you'll be free to go. You have a blessed day.
Okay, you too. Thank you.
Keith Williams. Keith Williams here. Eugene Booth. Do we still have bond conditions in Eugene Booth's case? That's cause number 330462. This is cause number 330462, case is style, the state of Texas versus Eugene Booth. Mr. Booth, is that your full name?
Oh, yes, sir.
How you doing, Mr. Booth?
I'm doing fine.
Okay, now, Mr. Booth, your case was reset to give you an opportunity to hire an attorney. Have you hired your attorney? Why haven't you hired your attorney?
Because I was in between jobs and I moved.
To the left, you see a set of blue dots.
So,
Walk in and
go
see.
ahead and proceed.
You need-
We'll proceed to the case.
You said you want to represent yourself? That's what you're saying?
Yeah.
Okay, well, you're gonna have to, there's some paperwork that you have to fill out.
Mhm.
And that's the paperwork that we went over before. Just have a seat. The bailiff is gonna give you that paperwork.
All right,
Just have a seat, and when you finish, we'll call you back up.
all right.
You guys, okay, yeah. You could have a seat.
All right.
Michael Wayland Taylor. Okay, Mr. Taylor, your full name is Michael Wayland Taylor?
Yes, sir.
How you doing, Mr. Taylor?
Okay.
That's good. Now, Mr. Taylor, your case was reset to give you an opportunity to hire an attorney?
Yes, sir. I was just requesting one more extension if you don't mind.
Okay,
I got about half the money looking for
how much time do you need?
30 days.
30? Okay, we could reset Mr. Taylor for 30 days. You're gonna stand on the far end in front of our coordinator,
Thank you, sir.
all right?
Just let us know who's coming from account. And he has cards.
Okay, is it a case that's on the docket?
Yes, sir. I have a general announcement.
Is he here?
No, sir. He's driving from McAllen. He just informed my legal assistant that his car is broken down.
Okay, well, he could appear by Zoom or by telephone, if you
We
can.
were gonna plea him out this morning.
Okay, I mean, if he's not here, you can't please, so I mean, we
Oh,
can,
obviously.
yeah, we can probably reset him, but you need to make an appearance.
Okay, let me see what I can do.
Okay. We're in session and cause number 329-104. The case is styled the state of Texas versus Mark Anthony Mendez. We have Mr. Mendez appearing via Zoom.
Yes, sir.
Okay, Mr. Mendez, how are you doing?
I'm doing great today. And yourself, sir?
I'm doing fine, thanks for asking. Mr. Mendez, you're here represented by your attorney, Attorney Scott Rennick. Attorney Rennick, how are you doing?
I'm good, Your Honor, thank you.
Okay, now, Mr. Mendez's case was set on the announcement docket. Mr. Rennick, you have an announcement?
Yes, Your Honor, we would like to spin a plea docket. It was going to be our intention to plead this morning, but due to unforeseen car problems Mr. Mendez has because he lives in McAllen.
Okay.
This morning couldn't get here.
Okay, how much time do you need?
Not a lot, Judge, whatever, the next time, I just need your range.
What's standard 30-day
30
recess?
days is perfect, Judge.
Okay,
She's 25.
what is it?
225.
Okay, so the case is gonna be, Mr. Mendez, your case is going to be reset until February 25th of 2022. Your attorney, your bonds will be given copies of the reset date. Stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
You too, sir.
All right,
Thank you, Judge.
all right. Okay, Mr. Rennick, you can get your reset. Once you get your reset, you'll be free to go as well.
Thank you, Your Honor.
Okay.
Your Honor, the state and Mr. Booth, who is representing himself, have reached
Excuse me, Your Honor.
Mr. Booth, would you please come forward? Okay, this is cause number 330-462. The case is styled the state of Texas versus Eugene Booth III. Mr. Booth, is that your full name?
Yes, sir.
How you doing, Mr. Booth? Now, Mr. Booth, I have before me two documents. First document I have is titled Judge's Explanation to to defendants without an attorney. Mr. Booth, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line stating that I want to waive my right to an attorney and represent myself?
Yes, sir.
Also, I have another document that's titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Mr. Booth, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Booth, prior to signing and initialing these two documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Booth, you'll be representing yourself. It's my understanding that you and the state have reached an agreement concerning your case. Is that correct?
Yes, sir.
And we need to have this case reset.
Yes, Your Honor, the state will be recommending that it be placed in the BIP program.
Okay. Does he have a sign-up date?
The next sign-up date is February 8th, I believe.
And he'll be able to sign up at that time? Do we know if not?
Well, no,
Because I think he has to get on the schedule or something.
Yes, Your Honor, I have to turn in the recommendation.
Okay, let me do this here. The next one after that will be in April, right? Because it's every 2 months? Or is, or different?
Yes, Your Honor.
It's the same time of what's called a pretrial diversion, right?
Yes, Your Honor.
Okay, so what we're gonna do, we're gonna reset this case to the second week in April,
Yes, Your Honor.
okay? That'll give you enough time to sign up and get into the BIP program, hopefully. So this case is gonna be reset. Give us a date in April, second week of April.
April 8th.
Okay, so this case is gonna be reset to April 8th of 2022. Mr. Booth, you can stand on the X in front of our court coordinator, get your reset. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you, Your Honor.
You're welcome.
What's the name of that program you did?
BIP, Batters Intervention Prevention Program.
What's the first name? I mean.
This is cause number 327480. The case is style the state of Texas versus, is that Geraldo De Leon Jr.?
Yes, sir.
How you doing, Mr. De Leon?
Doing good.
That's good. Mr. De Leon, you're here represented by your attorney, Ms. Laura Carrazzo. Ms. Carrazzo, how are you doing?
Doing very well, thank you.
That's good. We also think Mr. Ned Jones is with the probation office. She's appearing via Zoom.
Yes, sir.
Ms. Jones, how are you doing?
Yes, sir. Finding yourself.
I'm doing fine. Thanks, Jackson. And Mr. Boyd, will you be handling the case?
Yes, Your Honor.
Okay, and we have Mr. Daniel Boyd, who is representing the state of Texas, a district, Jefferson County District Attorney's Office. Ms. Perrazzo, I have before me a motion to modify community supervision.
Yes, sir.
Would you like to proceed?
Yes, sir.
You may proceed.
Okay. Would you state your name for the record?
Geraldo De Leon Jr.
And Mr. De Leon, where are you employed presently?
For accurate inspection.
Slow down just a minute.
Yeah.
I know you're a little nervous, but let's just
Accurate inspection.
accurate,
Accurate.
okay. And what do you do there?
Project manager.
And how long have you been employed there?
This time around since late June.
Okay, late June of 2021?
2020. Yes.
Okay, and prior to that, where were you employed?
I was working for Miss Strauss Group.
Where?
Miss Strauss Group.
Okay, and have you been employed, let's say, for the last 3 or 4 years?
Yes, ma'am.
You were placed on probation on February the 1st of 2021, is that correct?
Yes, ma'am.
And that was for a DWI that was enhanced, that was greater than the blood alcohol content greater or equal to 0.15, and you were sentenced to 2 years of probation with the Jefferson County Probation Department, is that correct?
Yes.
Now, one of the conditions of your probation was that you have an interlock device placed in your car, is that correct?
Yes, sir.
And was that done?
Yes.
And I understand that in April of 2021, there was a violation
Yes.
and there was an administrative hearing.
Yes.
And can you tell me what happened at the administrative hearing?
Well, from the beginning, to be very honest, it's hard to go into probation being only 24 years old and then kind of having to accept that you have to hang out with all your friends and just, I guess what young 20-year-olds perceive as fun. So I made a mistake and, had a little bit of fun and got me into trouble and I had to have an administrative hearing.
And what happened at that hearing?
There was a recommendation for me to enter a supportive outpatient program and I was given another chance. So I did the program and I completed it.
Okay, and since then, have there been any other violations?
No, ma'am.
And has having the interlock device created a burden for you?
Yes, it has.
And how?
Aside from having to do a monthly payment, any vehicle service as well, I have to pay just to get it serviced. Just the little things here, having to wait to turn on my vehicle, having to get it serviced every single month, missing work for it.
How much does it cost every month?
I believe it's about $80 every month. And then if I want to get it serviced, it's another $80 on top of that.
Okay, and it's been almost a year since you've been on probation. We're approaching the year, is that correct?
Yes, ma'am.
And do you feel like you've learned your lesson?
Yes, ma'am.
Is it your intention, if the device of the court orders that interlock device be removed, that you drink and drive?
No, ma'am. I don't want to go through this again.
Okay, are you married?
No,
Do you have any children?
no,
And who do you live with?
alone.
Okay, and so you support yourself
Yes,
and you're the sole supporter
yes,
of yourself. Nobody's helping you, correct?
yes, ma'am. And also help with my family back at home,
Okay, back at home.
Brownsville, Texas,
Okay,
yeah. Where they live.
okay. Prior to you being placed on probation, did you have any prior convictions for any felony or misdemeanor offense?
I just had a reckless driving when I was 18. That's the only one I've had since then.
Okay, but you've never had a felony conviction?
No, ma'am.
I pass the witness.
There's no question.
Okay, now, Ms. Jones, did you had anything, do you have anything you wanted to, say in reference to, this application?
Your Honor, I will let the court know that Mr. DeLeon, since the administrative hearing that we did on him, he did turn things around. He's in total compliance with the conditions of his probation order. He's ahead on his monthly payments. He's completed outpatient treatment through Harris County CSCD, and the interlock reports from the last 4 months have been reviewed. I didn't go back any further than that, but there were no indications of violations on those reports. So I will say that he has made great progress since the administrative hearing. He's doing well, no violations at all.
Okay. Now, looking at, just looking at the application, the statute that was, I think it was 22.8.202 that deals with shock probation. That didn't have anything to do with the modification. I think modification will be under, is that 22.052? Let's see it first. Okay, now, under Article 42.408, Section E2, Section F, where it says that a court shall require the defendant to obtain an interlock device at the defendant's own cost before the 30th day after the date of conviction, unless the court finds that to do so would be in the best interest of justice and enters the finding on the record. The court shall require the defendant to provide evidence to the court within 30 days, within a 30-day period that the device has been installed on the appropriate vehicle and order the device to remain installed on the vehicle for a period, the length of which is not less than 50% of the supervision period. Now, just by reading that, the court had ordered the device throughout the entirety of the probation. Okay, where I don't see there's a statute that says that the court has the authority, that specifically speaks to a modification in reference to an interlock device.
Your Honor, the statute that I quoted in the actual motion is 42A.202. I'm not familiar with the statute that you're talking about. I think in the best interest of justice that the court has the authority
Yeah, but I
to
think,
modify the terms.
yeah, but 42A.202 deals with shock probation. It doesn't deal with, and that only deals with the we don't give shock probation in a misdemeanor case. That's a felony case. That's when a person has been sentenced to, I think it's 10 years or less in jail time. And then within 180 days, they file a motion for the court to reconsider to put the person on shock probation. So this is not, that's what you requested in the, that's the request that's in the motion. But I know that you said he had one violation, but he has a prior conviction for reckless driving. That's he had mentioned that.
Yes, sir,
And I
but
think
it is not a felony.
Right, and the facts in this case also show that Mr. DeLeon I think on the facts, his car was, he ran his car in a ditch. Um, uh, And plus, his breath test was, 0.21, which was almost 3 times the legal limit, if I'm not mistaken. So, he did have, now he said that his reason, I guess he's saying that it's a burden on him for making the monthly payments, and paying a service fee each month. That's just part of the requirements of an interlock. I don't think probation probation is a burden on everyone, because you have to report, you have other conditions, you have community service, you have payments that needs to be made, and if individuals are not able to make payments, there are statutes that a person could, there are tools or motions that individuals can bring before the court, and the court can review the motion, review the evidence, and decide based on the law and the evidence whether or not fees should be reduced. But he didn't ask for his fees to be reduced. He asked for the interlock to be removed. I don't think it's in the best interest of our community at this point. Well, I don't think it's within the best interest for him to have his interlock removed, because it's a burden on him paying for the interlock and having to have a service fee that he has to pay on a monthly basis. So based on that, the court is going to deny the motion to modify. The court does not believe that it's in the best interest to modify his probation based on what has been brought forth before the court today, and that's the ruling of the court.
Yes, sir. Thank you.
Thank you, Judge.
Okay, you're welcome.
Your Honor, I don't know if
Your other client is,
Mr. Jones,
no, he's not on yet.
okay,
Okay,
let me call and find
okay,
out.
that's fine.
Thank you.
Mr. Kenny Williams?
Morning, Your Honor.
Okay, good morning. Now, Mr. Williams, you are pro se. That simply means that you're representing yourself. Is that correct?
Yes, sir.
Now, Mr. Williams, was he supposed to hire an attorney? Hold on a minute. Look in his file, see what the judge's explanation of rights is. This cause number is 329-406. Did it say anything? So, Mr. Williams, now you are what we call pro se. That, now have you, this case is set for an announcement. And what the announcement is, you can tell the court, whether you're ready, whether you want your case to go to trial, you announce plea, or whether or not you need some time, more time, maybe to get some discovery. I don't know if you have received
Yes,
any
sir.
discovery.
I still need some more time, Your Honor, because I still haven't received the discovery. And I still need to give my witness statement and everything because my witness is running late. She's supposed to be online this morning, so she can,
Okay. Okay, now,
so we
Mr.
can't make that announcement.
Okay, now, Mr. Williams, you only need witnesses when you have your trial. Your case is not set for trial. This is just
Okay.
set for an announcement.
Yes,
Okay,
sir.
so you need some more time to get with the state to get the, so you can have access to the evidence that they have in your case?
Yes, sir.
Okay, let's reset it 60 days. Are you the prosecutor on it?
Yes, Your Honor, I am.
Okay, now you'll have to get in contact with Attorney Blake Ham with the District Attorney's Office for that discovery. He's the gentleman that you see on the video standing in front of the bench.
Yes, sir.
Okay, so you have to get in contact with the DA's office and ask for Blake Ham.
Blake
Okay.
Ham?
Yes, give me a, what's that? And Mr. Williams, your case is gonna be reset to March 25th of 2022 to give you opportunity to get that information and give you an opportunity to talk with Mr. Ham regarding your case. Your bondsman will be given notice of your reset. Stay in contact with your bondsman. You are free to go and you have a blessed day.
Thank you, Your Honor. You have a blessed day too.
All right, bye. Okay, the court is in session and calls number 330446. The case is style of state of Texas versus Christopher Paul Avalaz. We have Mr. Christopher Paul Avalaz, who is appearing via Zoom. He is represented by attorney Dustin Galmore. Mr. Avalaz, you could take your mic off of mute. Mr. Avalaz, how are you doing?
I'm doing okay, Your Honor.
That's good. Now, Mr. Avalaz, you're represented by attorney Dustin Galmore, who's also appearing via Zoom. Mr. Galmore, how are you doing?
I'm great, Judge. How are you doing today?
I'm doing fine. Thanks for asking. Mr. Galmore, what is your announcement in Mr. Avalaz's case?
We'd like to place Mr. Avalaz on the trial docket, Your Honor.
Okay, just hold on for your reset date. Just hold on. That's what he said, trial. Okay, let's see. Macintosh. Bring him on in. Anderson, you'll be next. What is it? Okay, Mr. Avalaz, your case is gonna be reset for trial on March 14th of 2022. Mr. Galmore, your reset of this trial date, March 14th, 2022, will be sent to you. And Mr. Avalaz, stay in contact with your attorney. This will conclude your case. You're free to go and you have a blessed day. And Mr. Galmore, I think this is your only case today. Is that correct?
It is. Thank you. Thank you, Judge. Y'all have a good day.
All right, you're free to go as well, and you have a blessed day.
You too.
Next case is cause number 326668. Case is style of State of Texas versus Larry Darnell Anderson Jr. We have Mr. Larry Darnell Anderson Jr., who is appearing in court. Mr. Anderson, is that your full name? How are you doing, Mr. Anderson? I'm doing fine. Thanks for asking, Mr. Anderson. You were represented in your case by attorney Charles McIntosh, who is appearing via Zoom. Mr. McIntosh, how are you doing? You must be on mute, Mr. McIntosh, or your volume is down. Because I don't see that red mark saying mute, but your volume might be down. Yeah, we still can't hear you. Oh, you connected to audio? Yeah, we can see your head moving up and down.
How about now, Judge?
Oh, yeah, that's it. That's it. How you doing, Mr. McIntosh?
I'm sorry, I'm good now. I'm good now. I got it.
Okay. Mr. McIntosh, what is your announcement in Mr. Anderson's case?
Judge, this is our first appearance on this. I need to go over discovery with my client still. And so we just ask for a standard reset.
Give us a reset there. Okay, the case is gonna be reset until February 25th of 2022. Give me an opportunity to get with your client and go over the discovery. Mr. Anderson, your case is reset to February 25th of 2022. We're gonna give you a copy of your reset in court. Stand on the 4X. Once you get your reset, you'll be free to go and you have a blessed day. Mr. McIntosh, is this your only case?
I believe so, Judge.
Okay, Mr. McIntosh, your reset will be sent to you. You're free to go and you have a blessed day.
Thank you very much, Judge.
You're welcome. We have Mr. Porter, would you please call with a Misty Moss? Just have her to come in. This must be Miss, is that Jones, Jermichael Jones? Okay, I'll wait till he's connecting on the audio. Okay. We're in session in cause number 319046, case of style of state of Texas versus Jermichael Earl Jones. We have Mr. Jermichael Earl Jones, who is appearing via Zoom. His attorney, Ms. Lori Perazzo, is in court in person. Mr. Jones, your attorney informed us about your medical condition. We'll be praying that you have a speedy and full recovery.
Yes, sir.
Okay, Ms. Perazzo?
Yes, sir, we have received an offer in the case. This will be a plea, so if we could just reset this to the next plea.
How much time?
As soon as possible. Less than 30 days, 2 weeks. Well.
Yeah, I was wondering about
never
Mr.
mind.
Yeah,
30
Mr.
days.
Jones, probably 30 days, yeah.
30 days.
Yeah, he's on the motion to revoke probation. He's the second person.
Say you want him on a plea doc?
Yeah, he's gonna plead on his case when he come back.
For the probation officer to be here, I need it on the motion.
Yeah, it's gonna be on the same day, but she announcing that when it's reset, she's gonna plead,
Okay,
right?
yes, sir.
Yes,
Okay.
but that's not what you said, correct?
Right.
Okay.
That is
I
not what I
want to
said.
make sure I'm not correct. Okay.
Okay,
How long? 30, 60,
30.
Please.
225?
Okay, this case is gonna be reset to February 25th. Mr. Jones, your attorney and your bonds will be given notice of the reset. You're free to go. You have a blessed day, and again, praying that you have a full and speedy recovery.
Thank you, sir.
All right, you're excused. And Mr. Razzo, this is your last case. You're free to go. And to get your reset, and you have a blessed day.
Thank you.
Is that Misty Moss?
Probably went to the restroom.
Okay. Okay, we'll be in recess.